and you can talk to her when they bring her out. Here's the issue. She retained an attorney. That attorney did not have a motion to withdraw signed. She's still the attorney. And what ended up happening at that hearing is there was an issue where the defense attorney said that the father of her client is interfering with her ability to represent her. But the father ended up turning over medical documentation to the defense attorney. And then that was that. There was no re-urging of the motion to withdraw. And there's nothing in the system that shows, one, that a motion to withdraw has been signed. So if a motion to withdraw has not been signed, that's still the attorney. And correct me if I'm wrong, for the MAC to appoint her an attorney while she has a retained attorney in felony court, that appears that may be interfering with the attorney-client relationship. And then the next questions become, if she was able to afford to hire an attorney, then why is she receiving appointed attorney, a court-appointed counsel? So if you wish to speak to her, you can. But what I can tell parties is I am not proceeding unless Ms. Sawyers appears because she's listed as her attorney of record.
May I address the court?
I mean, no, that's what I've said. So if I'm not proceeding without Attorney Sawyers being here because technically that is her client. And I haven't received a motion to withdraw.
Have, and it's on file.
It hasn't been signed.
The order, you're correct. The motion has been signed by Ms. Sawyers. The order has not been signed, but there's a YouTube video in which your court said that as soon as Ms. Aaron reappeared, you would sign the order. She's here. So we're requesting that you sign the order.
Ms. Sawyer needs to be here.
She is in a jury trial for several days. So you're saying Ms. Aaron is going to
Have a seat. Have a seat. Thank you. All right, so I'm going to proceed with this hearing. Excuse me, I don't understand the attitude. Have a seat. I will take your matter up. I was explaining to you what the issues were. I don't know why people don't understand what I'm saying. I've explained to you what the issues are. You see these attorneys sitting here. I was giving you all opportunity to speak to her so you can understand what the court's issues are. That's where we are.
Judge,
and then I'm going to take this hearing up and then we'll continue with your matter.
I'm not the court appointed attorney, as you've already mentioned. So
No,
I'll
you're
contact
not.
Ms. Sawyers.
Thank you. All right, are you all ready?
Well, waiting to hear from Mr. Harris.
Oh, okay. So have you all had a discussion before you came?
The parties have not on this matter.
All right, so do y'all need to discuss things in the jury room? You can, because I know it's more than one attorney, or do y'all want to discuss things now amongst yourself before we go on the record?
I am willing to have a discussion, but I was available in the hallway and was not approached by the state.
All right, well, we can do it now. I'm here, you're here, we're all here, so you all can do it. If you all wish to do it in private before coming before the court, you can.
Happy to, Your.
All right. So the jury room is available, or if you all want to do this here, you can do this here. I will not be paying attention to your conversations unless you're on the record with the court.
Sure. Jury room is unlocked, Judge?
Yes.
Thank you.
All right, did everyone get a chance to speak with each other?
Yes, sir.
All right, and is there still missing information?
Can I guess, start us off, because I won't be able to finish, but the defense,
Well, let's go on the record.
oh, sure.
All right. Court is on the record in 2023 CR 11510A, 11510B, and 11510C. Attorneys for state and defense are both present. And everyone, if you'll just remember to state your name so that the court reporter will have it. Yes.
This is Jeff Mulliner for the state of Texas. And so my understanding from witnessing the conversation and asking a couple of clarifying questions is that the defense is certainly interested in getting access to evidence.com cloud-based software. And the court previously had a question, is that proprietary? And the answer we now know is yes, it is. And Jim Kopp is here on behalf of the city of San Antonio. And so, of course, in conferring behind the courtroom and the jury room, the question was raised, would the city have an objection to providing a username password to the defense so that they could access for themselves this proprietary software? And the answer that will be provided if asked is that yes, the city will object through Mr. Kopp. And so then the further discussion was trying to get at what is there that the defense is seeking that would be on that system. And at a minimum, my understanding is that there would be entries that could be made by officers, either administratively or otherwise, that could be referred to categorically as either bookmarks or comments. And the suggestion is that a piece of paper could be printed that would include a bookmark and additionally a comment if such a comment existed. So now what is on this proprietary software could be reduced down to a document. And then when the question is raised, would the city have an objection that they would raise with respect to releasing those documents? And the answer is affirmative. Another question was raised, how long would it take to acquire documents establishing the bookmarks and the comments, if any, that exist with respect to what we're talking about here, 42 separate and unique body cams, and not being facetious, because of course we're among ourselves back there, but the answer is probably quite a bit of time, like an unstated.
Oh, well, let me just tell you, if this exists and if it is in document form, or it could be given in document form, then it needs to be given in document form. Here's my question. How long has Attorney Cobb been working in the position that he's working in? I mean, it's been more than since January, right?
I'm guessing over a decade, but I don't really know.
Well, no, the reason why I asked that is because he's been in the position for longer than January. Discovery in this case has been going on since January. He's been in that position at least since May, when the acknowledgement of discovery was done. And everybody is just now saying, oh, we don't have this. So print it out, give it to them, or either do it by, and if somebody wants an order for the court to sign, I will sign, print it out, give it to them, or either let them view it under the watchful eye or whoever has access to the information. But that's where we are. And everybody has much more than 10 days to make that happen.
I was,
Your Honor, may I address the court?
Oh, well, after he finishes, then I'll allow you to address. Everybody will have a chance to put whatever they want to put on the record.
sure. And so I was just kind of trying to highlight for you what what you would have learned if you were a fly on the wall back in the room. Really just kind of summarizing.
Probably a butterfly, not a fly.
Of course, absolutely. So the conclusion is that yes, what is included as bookmarks or comments on these 42 body cams could be identified and printed onto paper. How long would that take? Not able to say. With the collection of individuals we had back, that there was nobody that could definitively say this is how long it would take. We then further learned that there is a person that would have likely the greatest amount of education, training, and boots on the ground experience with these matters. And as I understand it, that would be a Sergeant Bobby McGee. So I think we've identified a person that is ripe for bringing into the discussion among the parties trying to resolve this. And so that's really all I was doing, is kind of summarizing for you what was discussed back there. And that's
Well, I'm
about
not
it.
even counting today, but with weekends, that means that y'all have 16 days before the 20th, which is when jury selection will happen, for everybody to have that.
Mr. Cobb indicated that his last day before he will be absent for 3 weeks is this Friday. And I learned that there's not really somebody that is designated to replace his unique duties when he is not in. So I'm just letting the court know that he has indicated that it would be his intention to object to direct access to evidence.com by the defense, and would also be indicating his intent to object to these documents at such time as they could be created. And we don't really know how long that would take, but maybe
Well,
he has a better
Then we're
idea.
going to count today at, what does that clock say, 2:32? People need to start printing that to get that ready. And then the court will make its ruling on that. But I can tell you this, the defense should have that to view it, to see what's on it. I don't know why people waited to the last minute to do this, but this is where we are. And what I'm telling parties, September 20th at 9 a.m., this case, we will be having jury selection. Now, I don't know why I had to be the person to discover that this software is proprietary. I don't know why I'm the first person to ask that, but I have asked it. They're saying that they're able to print out whatever, then I can understanding them on my knowledge of items that are proprietary. I can understand why they would not want to give them a password and code to get into the system. But they need to print out what they're saying that they want as it relates to this case. You can turn it over to the court. I'll review it and see whether or not it's something that the defense should or should not have. That's where we are. But this case, the voir dire is happening on September 20th. So everybody, you have today, Wednesday, Thursday, and Friday. And when it comes to people in their employment, this is what I always ask people when they say, oh, this is the only person who can do it. And you know what I say, God forbid something were to happen to that person. You just telling me nothing's going to happen. That job is done. It's like, oh, if something were to happen to this heart surgeon, then nobody else can do heart surgery. We're just done. Nobody's irreplaceable. If something were to happen to me tomorrow, you telling me there are not going to be any cases heard in the 187th? Yeah, they'll find somebody to replace me. Everybody's replaceable. So if Attorney Cobb is not going to be here, there's somebody else there. If not, when he retires, I guess people will pay him billions of dollars. Please don't retire because you're the only person who can do this. I don't see that as the case. Although I admire you, Mr. Cobb.
I can. This
Oh,
is a
yes,
little
please.
theoretical. We believe we can do the download, and I'm gonna find out real fast.
Thank you.
If I decide to file a motion to quash, I will do it in the next day or two.
Okay.
Rule on it without my apps, I don't need to be here. I trust the
Okay.
court.
All right, well, let's, if you're gonna do that, then let's file it today.
That's what I'm
I
sorry.
mean, I'm sorry, if you're gonna do that, where you want to do a motion to quash, then let's file it today. I'll hear it at 9 a.m. tomorrow.
I'll try to do it today. I just found out about this at 1 o'clock and this download has never been done before
Okay.
pursuant to a request of
Oh,
defense.
look at us. We're making new things.
Done. I just don't know.
All right. I
So I don't
appreciate.
want to make a promise, but
All
I
right.
think it can be done.
All right. And I'm sure that nobody will object if you want to do an oral motion to quash. And if you want to, Mr. Cobb, if you want to zoom in, I'm sure no one will have any objection to your zooming in if you decide that you don't want the defense to have whatever materials it is.
I'll bring him for an in-camera inspection.
Okay, awesome. And so can you have that here tomorrow by 9 a.m.?
Let me put it this way. If I can't get them all produced, I'll get some produced so you'll know what we're talking about.
Okay.
And then they can continue the process.
All right, awesome. Then if you can even have it here this afternoon before 5. Let's try. We'll all be here. We'll wait.
Really pushing, but I don't know, but we'll do what we can.
All right, let's see if we can have it here before 5. If not, if you'll just contact the court. Does anybody have any objection to me giving Mr. Cobb my cell number? He may still have it from when I was in the DA's office, but just to call me to let me know if he'll be able to make it back by 5. Any objections?
Of course not. We have no objection.
Defense?
No, Your Honor.
All right. Mr. Cobb, let me give you my cell.
We have it. I
Maybe
kept all
you
the,
may.
yeah, I'll let you know if I can get where we're at.
All
Be
right.
excused.
Yes, thank you so much.
See you guys.
Bye, Jim.
All right, so everyone, we'll take a recess.
I had,
Yes,
matter of housekeeping, did you
of
want
course.
an order prepared? And if so, what dates or deadlines or times? did
Oh,
you
well,
want?
let's see if he has it here by 5. And if he has it here by 5, I'll review it. And we're going to stay here. It won't take me that long to review it. I'm a quick reader. And then I will let you all know today before we leave court today.
Do you want us back by 5 or do you want us to check with the coordinator to see if we should be back?
No, I mean, we're going to be back by 5.
Okay,
All right. And what I'll do is, I think I have some of your numbers. If everybody will leave their cell number with me, and I'll include everybody in the group chat. I believe, Mr. Lunan, I think you have my number. I know David has my number. So if you all can coordinate and put everybody in one group chat with me, and that way I can text you all and say, Attorney Cobb is here, come on back. And I don't think people are going to be traveling that much anyway, because my understanding, it's flooded here in San Antonio. Major flooding. I think I may have your cell number too, but just in case. Thank you. All right, so is there anything else?
may we be excused until 5?
Yes.
Thank you.
And just if you all could stay maybe within 20 minutes or so, because he may be able to tell us something before 5.
Oh, it's that late already?
Well, it's almost 3.
Okay. All right, we'll be in the hallway.
All right, sure. And if your clients have somewhere else they need to be, if you want them by Zoom, they can be by Zoom instead of staying. All right.
Okay, thank you.
All right, thank you.